Rights Commission, the Honorable Attorney General, the committee who turned up human rights in large numbers, and the members of this committee who turned up in large numbers. The committee praised that this report is considered and the recommendations therein. The committee praised that this report is considered and the recommendations therein adopted. As I stated, Right Honorable Speaker, four of our colleagues exercised rights exercised under Rule 205 of the Rules of Procedure to author under Minority Report 205 of the Rules of Procedure to author a minority report issues areas of dissent. With your permission, may I invite the Honorable Jonathan, with your permission, to present the invite the Honorable Jonathan Odur to present the minority report.
Honorable Jonathan.
Thank you, Right Honorable Speaker. The first area of dissent is the first safety area of dissent, Dr. Kizza Besigye, known as Uganda Remand 1867 of 2024, fear of being killed in prison. The committee was informed by Dr. Besigye that he is in fear of being killed in prison through poisoning. His biggest fear is that the state, being the complainant in his case, the persecutor, and has the command and control of the Uganda prisons, puts him in danger. This fact, the Commissioner General of Prisons confirmed knowledge of the fears of Dr. Besigye and stated that it has put the prisons authorities in a precarious situation, having a prisoner under them who fears being killed by them. The second area of dissent is the opening of the 2 out of the 4 security locks to access Uganda Remand 1867 of 2024, retired Colonel Dr. Kizza Besigye, who informed the committee of an incident where deep in the night, to be exact after midnight, 2 of the 4 doors were opened. This scared him into shouting loudly, and the people opening retreated. He sought an explanation, and 3 different versions of events were told to him. The first, that there were some items forgotten within his detention facility. Secondly, he was told that the opening of the doors were because some padlocks had not been locked, so they had returned to lock it. And the third explanation was that it is routine inspection by the prison authorities to come into the night and inspect whether the prisoners are inside. This made him fear that the contradiction was not justified. Point number 3 of dissent is the solitary confinement of Uganda Remand 1867 of 2024. It was the submission of retired Colonel Dr. Kizza Besigye that he was being detained alone and is not allowed to interact with other prisoners, including attending prayers on Sunday with the rest of the prisoners. This is contrary to Section 57C of the Prisons Act 206. The Commissioner General of Prisons informed the committee that the isolation of retired Colonel Dr. Kizza Besigye is first for his own safety, but also because Dr. Kizza Besigye has the capacity to excite the prisoners, which might spiral out of control. The Uganda Human Rights Commission, in its written submission to the committee, noted that solitary confinement, when used excessively under harsh conditions, can be considered a violation of human rights due to its detrimental effects on the mental health and well-being of a person. In fact, Dr. Kizza Besigye complained of being in a difficult mental health situation which cannot be handled by the medical personnel at Luzira prison. Point of dissent number 4 is confiscation of the Christmas greetings to Ugandans. Uganda remand 1867, Dr. Kizza Besigye wrote a Christmas greetings and message to Ugandans, and it was confiscated for having 2 words, freedom and justice. There was no plausible justification by the prison authorities for detaining a message, confiscating it, and eventually sentencing that message to death, and the execution of the message was done. Point number 5, which is the last in dissent, is the denial of the advocates, denial of access to advocates to Dr. Kizza Besigye. The committee learned that Council Lukwago areas advocate to retired Colonel Dr. Kizza Besigye was denied access to his client on a critical day when the court-martial was sitting the next day. The lawyers had papers, applications, and affidavits that needed the signature of the accused persons. The Commissioner General informed the committee that he denied the lawyer Lukwago areas access to Dr. Kizza Besigye, since that same day there were members of parliament who were visiting Dr. Besigye, and he could not allow both the lawyer and the MPs to access him. Our recommendations. The minority recommends that Parliament takes keen interest into the fears of retired Colonel Dr. Kizza Besigye of being killed in prison by poison. 2, the minority recommends that the trial of retired Colonel Kizza Besigye and subsequent detention in Luzira prison be terminated and any trial be held under the civilian authorities. I beg to report, this report is signed by Honorable Nyeko Derek, Honorable Nabagabe Kalule Flavia, Honorable Zake Francis, and myself. I thank you, Mr. Speaker.
Thank you, Honorable Jonathan. Thank you. Honorable colleagues, we've received the 2 reports. Our members of the committee are constrained to debate the same. So I'm just going to allow me, because these are our findings, we shouldn't take, okay, that long. So I'll start 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, and I'm picking you, 14, 15, 16, 18, 19, 20, 21. I've picked you. You follow yourselves in that order.
Thank you. Right.
Okay. What we do, I hope Clark has helped me to note, we can mix. Okay? Yes, let's try to mix.
Thank you, Right Honorable Speaker. I'd like to thank the Chair for the report and for some of the good recommendations. I know this report is only not concerning Luzira. Some of the things he has mentioned are happening even elsewhere. And I know the committee has even ever moved to other prisons and saw what is happening there. So some of the recommendations should be taken up for action, but most commonly, the congestion is almost everywhere in all the prisons in the country. Then secondly, the prolonged pretrial detention. Even the Attorney General, I think, had already mentioned about it. So it's a very, very big concern that prisoners stay long when they are not tried, and also that contributes to the congestion. So I thank you, Right Honorable Speaker.
Thank you. Honorable colleagues, on these issues, I saw the reaction. There is a matter which has been settled, okay, from what I see, because the majority report touched it and the minority report didn't didn't disagree. There had been perceived a situation that Besigye is denied food. I think that's a settled matter now. He appointed 3 people who can take for him non-cooked food. If you are not among those 3, because the public should know, because you know they can go to Ruzira carrying food and all that. If you are not among those 3 who were nominated by Besigye, your food won't be allowed in. And the same applies to Mr. Haji Obed Kamrege. I think that's a settled matter. Honorable Jonathan, on that, because I wanted us to shape our issues very well. We know the issues which were raised here.
Yeah, thank you, Mr. Speaker. I would like to confirm that position, that any member of the public that would like to support Dr. Besigye is free as long as the food goes through those 3.
Okay.
Because, as you know, once you're in prison, you are limited and support is required. So it is not like the rest should not. But
Okay.
it should also be on the record initially
Yeah.
that the main point that was raised here was that Dr. Besigye was denied food. It is true, he confirmed to us that when he went to prison at first, he was allowed to access his own food and prepare. Then at some point, the prisons changed the rules and said, we will not allow you to prepare your own food. Mm-hmm. What we shall allow is that you give us money and we buy for you from the canteen, the staff canteen, or you send us outside and we buy for you. Now that is linked to his fear. So he refused to eat what ordinarily would be a hunger strike. And the prisons eventually reconciled and agreed that yes, you can now resume and get your supplies, but because you have accused us that you are not safe here, we want 3 people to be the one to bring for you food. So that matter has been settled, although it was a concern.
Okay, thank you. Honorable Christine. Honorable
Thank you.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I think it is important for this country to get the truth. I was among the people who went to Ruzira. The reason is given by Dr. Besigye for not eating food. And the prison is also answered. They said they were receiving many visitors bringing food to Dr. Besigye. And they were worried. So what they said, it was just an oversight. It was a point of agreement on whether they should continue bringing food for Dr. Besigye or he buys food from the prison canteen. And because they wanted to safeguard his life, they said as prisoners, we are not going to allow all these people whom we do not trust to bring food for Dr. Besigye. So the only idea was for him to buy food from their safe stores. So Dr. Besigye was also adamant. He said, I cannot trust the jailer. Therefore, I can only designate my person who will be supplying me with the food. That was what he said. But for you to say that they were forcing him to buy food from the prison, I think we need to tell Ugandans the truth, other than exciting the nation. This is what, and Right Honorable Speaker, the gentleman was very honest. Even what our colleagues from opposition were pushing him to say otherwise, Dr. Besigye was honorable enough to tell the committee the truth and the whole truth. Even the issue of his staying in a single room, it is not true. These are people just like those of you who have rented. You have an apartment, and one of you staying here, another one here. It is not true that he's even staying in one room and he's put alone there. Even access to worship, he gets even a bishop to attend to him religiously. So I think it is important to tell the country the truth.
Thank you. But Rook, honorable colleagues, me, I see, apart from the tone, you presented the same. Apart from the tone, okay? Yeah, the only issue which I had there, which Honorable Wakori said, was it is being insinuated that Besigye was being forced to buy food from the canteen. But from the records I have, I interacted with members on both sides, opposition and NRM, who went to Ruzira. You're corroborating information, and I think we are moving very well. Okay? We are moving very well on these issues. Honorable Christine, then Honorable Nwagawa.
Thank you so much, Right Honorable Speaker, for this opportunity.
I'm picking from here and here, so that I remember.
Right Honorable, I want to appreciate government on a note that Dr. Besigye made a statement on improvement in the conditions in prison. It means that the effort of Parliament has been considered. I now want to support also one particular recommendation on the removal of the bucket system. And I want to agree that in some of our areas, the bucket system is no longer there. How I pray that it cuts across the country. And also to thank the prison leadership for the better handling techniques. Because surely, when we look at this situation, where Dr. Besigye is allowed to see his personal doctor on daily basis, whenever necessary, I am actually giving a reference that where he is allowed to see his personal doctor, that is okay, because there is no aspect of imposing doctors on him. So my prayer, Right Honorable, is that the improvement in the conditions in Luzira prisons should cut across the entire country in relation to the provision of water services. Thank you.
Thank you, Honorable Nwagawa.
Thank you, Right Honorable Speaker. I will respond to the two reports and begin with the one from the Attorney General. I would invite the Attorney General to reread Article 129 of the Constitution and see whether the reference to subordinate courts includes the reference to military courts or military tribunals as they are called, vis-a-vis Article 210 of the Constitution. And if you applied both the strict interpretation rule and the jus dem generis rule, whether you would import the provisions of Article 210 to Article 129. And I will respectfully disagree with you that military courts are envisaged as subordinate courts under Article 129. Secondly, in respect of police bond, well, thank you for the clarification, but you need to be very clear and advise the policemen who have now taken the presidential directive on banning giving of bonds, because the bond is giving of bond is a discretion. It's a discretion on the police, and you know the time, the constitutional time frame of bringing suspects to courts, the weaknesses in investigations and the like. So you must be very clear that yes, if you are to deny a person bond, make sure that you produce that person in court within 48 hours. Lastly, on the report of both the minority and the majority report of the Human Rights Committee, I believe they both agree, but essentially they both agree, but there are two areas. One, the idea of solitary confinement of a prisoner, especially who is on remand, because solitary confinement is literally a punishment. It is actually serving a sentence. So the solitary confinement of a prisoner on remand, to me, is illegal. It amounts to torture and must be condemned. And the prison officers must be cautioned and told in an explicit terms, they should not be confining a prisoner who is on remand to solitary confinement. Two, and lastly, wrong pre-trial remands. Mr. Speaker, we have allocated substantial monies to the judiciary. And actually the judiciary has over-decentralized. I even pity some of the recruited judicial officers who have been posted to sub-counties without any facilities. But unfortunately, the office of the DPP, which deals with people in prisons, has not been given matching resources to recruit staff. And this is an area that the Attorney General and the Minister of Finance should take it upon themselves. Either we halt the further expansion of the judiciary until we match the human resources, the office of the DPP, or do away with the judiciary in some of the areas. Because part of the explanation why we have prisoners on remand for these long periods is largely because the office of the DPP is not as facilitated as the judiciary. But we also need to caution the judiciary. There are provisions in the Constitution where you can give people, you can release people on their own cognizance after they have spent the mandatory period in a prison without trial. The judiciary is not using that opportunity, is not using that discretion. We really need to cut down the numbers of prisoners on remand in a prison who have not been tried. Person being in a prison for 28 years, honestly, and then you sentence him after? No. We need something to be done, Mr. Speaker, sir.
But by the way, on that issue, I forgot. I don't know. Well, the presiding officer had already pronounced that the Attorney General responds. But I think these are some of the issues which the committee should go and look at. For example, someone in prison for 28 years on remand, it just shook me. And it can happen to any of us. It can happen. 28 years, I don't know which crime we would have committed. I don't know which sentence that person will get. Procedurally, let me get the opinion of my colleagues here. Procedurally, I'm still just trying to get an opinion of the colleagues. No, mine which I'm on is different. I'm on someone who is in prison for 28 years. You're talking of Besje who went there yesterday. We are talking of 28 years. Okay? So, Honorable Chair rules. Honorable Chair rules. On that same person of 28 years?
He's not in for 28 years just on remand. He has never appeared in court.
For 28 years?
Because you can be on remand when you are appearing in court. But this very one, there are actually two. One has been there for 28, another one 16 years, and both of them have never appeared in court. And they're just waiting for the minister's order.
Now, because you see why, yes, Attorney General before Chairman rules, so that I seek my guidance on this.
Thank you, Right Honourable Speaker. When we appeared before the Committee of Human Rights earlier today, I appeared together with the Commissioner General of Prisons, and some of these issues were raised. We agreed that we are going to take 2 days, engage with the leadership of prisons and get all the necessary information and see the next step. Either ask for an automatic release or advise accordingly. But in 2 days, we'll be able to get
so
back.
So if you're asking for 2 days,
yes.
If you've agreed upon 2 days, can you update the House on Tuesday?
Yes.
Over the same?
Yes, Mr. Speaker.
No.
Mr. Speaker.
No, honorable colleagues, let us take it as if, no, let us not take it as if they mean to. No, because this came from the House itself. I'm sure they must have given more information, and there are more people.
Okay? Mr. Speaker, so, among the issues they raised, there were some who have been there awaiting ministers' orders. Those who are deemed mentally, and they have been waiting. So, but now we need to engage with the commissioner, okay?
Honorable colleagues, no, so, this matter, Honorable Katunda, I had wanted your guidance, but with the submission of the Attorney General, I've gotten a true picture.
Yes.
The Attorney General has said, they've agreed that within 2 days, they should sort this matter. Okay? And I'm saying 2 days, start tomorrow and Thursday. They even have an allowance of Friday and Monday. Then on Tuesday, the coming Tuesday, the Attorney General updates the House on the status of prisoners of that category and what they've done about it. And then we can carry it from there.
Thank you very much, Right Honourable Speaker.
Can we continue with the debate? Honourable Katuntu.
I don't, as you know, I don't always rise up on such issues. Right Honourable Speaker, we seem to be dealing with a systematic problem. It's not about Luzira. Yes. 20 years. This is not